are we at the point where we need the actual author of the work, or the person who took the picture or took the video, to come on the stand and authenticate it? And strictly speaking, that is the person that you need to authenticate it. No one else can, because only that guy took the video. So he's the only one who knows. But I imagine you have video experts that can also figure out if something's been manipulated.
I think we are getting to the place where the authenticity of the person who took the video, who can testify that it was not manipulated by AI, is going to start playing out in the courtroom very frequently. Welcome to episode 99 of the Weekly Docket, a podcast by the Silberman Law Firm where we talk legal news and practical law. Today is December 5th, 2025. I'm Phil Silberman, owner of the firm and your host, and I'm joined by Chris Heald, who's the supervising attorney at the firm. And Chris, how are you doing today?
I'm doing all right, Phil. How are you?
Doing very well. We've got a short show today. We're going to do one thing, but we're going to do it well. We are going to talk about personal knowledge and getting things into evidence and the process of what that looks like. And I know you just did a TI hearing where some of that came into play. Generally speaking, you might have a photo or a contract you need to get into evidence. And the real standard is, can you present a witness, go through the right process, show that the witness has personal knowledge to authenticate whatever you're trying to get in and get it admitted. That's generally what it looks like. Do you agree with that so far, Chris?
Yeah, I'd agree with you.
Okay. So let's talk a little bit about the process. Now, let's say you've got a lease contract that you need to get into evidence, and you've got a witness on direct. They've already been called. Let's say the witness's name is Joe, and Joe is the property manager, and you're trying to get a lease contract into evidence. So walk me through, what's the first thing that you do?
The first thing you do is you hand them the document and you say, I'm handing you what's been labeled as Plaintiff's Exhibit 1, because everything is being taken down by the court reporter. So you need a clean record of exactly what's happening in the courtroom, because there's no video cameras. It's just the written record. So first thing you do, you hand them the document. You say, I'm handing you what's been labeled as Plaintiff's Exhibit 1. Do you recognize that document? And pray that they say yes, because if they don't, it all goes worse from there.
Okay, so you've handed them the lease, what's been marked as Exhibit 1. What are you going to ask the property manager?
I'm going to say, do you recognize that document? And they're going to say yes. And I'm going to say, what is that document? And they're going to identify it. They're going to say, this is the lease that the parties in the courtroom entered into, that we entered into with the defendant, or the defendant entered into with us. And at that time, well, I don't know how detailed you want me to go. A lot of times the courts ask you to stipulate or agree on exhibits and hear any objections prior. And so I know there's not going to be any issues at that time. Then I just say, for the sake of the record, Judge, I offer Exhibit 1 into evidence, just because as soon as you start talking about something, you got to get it into evidence before your witness starts reading from it. But if your question is more, how would I do it in practice court, when my professor is making sure I do everything by the book and not taking any shortcuts? If you want a guaranteed way of getting the document into evidence, you would lay what we call a business records predicate. And you would ask them a series of questions to identify the document as a business record of the leasing company, the management company, so as to establish what the document is, the fact that it's not hearsay, the fact that it's authentic, to preempt all of those objections, and then I would offer it into evidence.
Okay, let's do the easy one first. Let's say you've given Exhibit 1 to your witness, and it says, yes, I recognize it. What is it? It's a lease contract. Did you draft the contract? Yes, I drafted it. And then you take it back from the witness and you give it to the judge. And you say, Your Honor, I offer Exhibit 1 into evidence. And then you wait for a ruling, right?
Usually what happens is the judge will look at the other side and say any objections, or just look at the other side and wait for them to talk. And then the other side either says, yes, Your Honor, I object on the basis of hearsay, or the other side says no objections.
Mhm.
And if they say no objections, then the court will say Exhibit 1 is admitted.
And do you have to show Exhibit 1 to the other opposing counsel, or do you provide them a copy usually, or no?
You provide them a copy. So what you want to do is you want to give the court reporter a copy, you want to give opposing counsel a copy, and you want to have a copy for the witness. So when you walk into court, you really want to have 4 copies.
Okay, which that's a lot you got to have going on in the briefcase there. You've got a bunch of documents you're trying to get in. So a lease contract might be like 10 pages. So you're walking around with 40 pages, paper clipped together or whatever, all marked as Exhibit 1, and you give it to opposing
That's why you
counsel.
bring a junior associate to carry the boxes.
A lot of stuff in there. And so you give it to opposing counsel, you give it to the court reporter, you give it to the witness, judge admits it, and then you can start talking about the document and asking questions about it.
Correct.
Okay, and if you're that's
Because if you don't, if they start reading from the document or talking about it, any lawyer is going to start objecting. And this, you can't read from a document that's not introduced into evidence. If they want to talk, they can talk, but they certainly can't just start talking about a document, because I need to be able to object to it, and it may not come in. And if it doesn't come in, you can't start talking about it.
Okay. So what happens if, will you typically, for lease contracts that are obviously, you might want that in, you might not object. Are you the kind of attorney, or do you recommend that attorneys just object to hearsay on every document and make them lay the correct predicate? Do you do that, or what's the strategy behind that?
You just informally address my strategy. The first thing is, do I want this? If I want it in anyway, I'm not going to object. If I know what you're about to introduce and I want it for my case, I want to talk about police, I'm going to need to talk about police, then yeah, my analysis stops there. I'm done. If it's questionable, then yes, I'll object. If it's going to make me look foolish, like a lease or a contract that is the heart of the issue, no, I'm certainly not going to object. But as we get further down the line, away from the lease we're fighting about or the contract we're fighting about, and we start getting into other documents, I will tell you my lean is always objection hearsay, because it is hearsay, but there are a lot of exceptions to the hearsay rule. And if nothing else, if they're not ready for a hearsay objection, they may not get documents in, or they may stumble, and they may get a little self-conscious, and they may not want to introduce all their exhibits now because they know Heald over there is going to object. So anything I can do to throw you off your game that's going to help my client, short of just being a jerk and annoying the court, because you always have to keep that in mind. You object, but the court starts getting annoyed with your objections, that's going to cause you problems too. So it's always strategically what's going to be best for your client.
Yeah. And so hearsay, if you go back to law school, I think I can even still remember it. It's an out of court statement offered to prove the truth of the matter thereof, or something like that. Does that sound right?
It's close.
Yeah. Essentially what you're pointing out is every document is an out of court statement. That's why you have to overcome the exception. And one of the exceptions we often do as real estate lawyers or business lawyers is lay a business records predicate. Do you remember much about, without having the rule in front of you, do you remember much about business records predicate, all the elements of that?
Yeah, you have to. In practice court, that was the one thing they made us learn. You're going to need it at all times. You better have that ready to pull out of your pocket at all times.
Okay, so give the listeners what you're looking to establish with business record predicate from memory. We'll put you on the spot.
Ooh, this is fun. Okay. So you hand them the document and you ask them, is that a business record, or is that a record that you're familiar with? Have you seen that document? Are you familiar with it? Is that a record that would be kept in the ordinary course of your business? Was that record made at or near the time of the events that are being recorded? Were the events recorded therein made by a person with personal knowledge of the events contained in the record? Is it in the usual course of your business to keep such records? And was that record kept in the usual course of your business?
Right.
So if you have the custodian of record, is a very loose term. It can be your client who's the single member of an LLC, or the apartment manager. The custodian of records can be anyone in the company, provided they have personal knowledge of the company's records. You lay out those 4 things. It qualifies as a business record of the company. you overcome the hearsay
Yeah.
objection.
And then you just, after you do that, you offer to admit it. And then hopefully the opposing counsel doesn't object again.
If they do, you just go to the next one, because the next one's always authenticity too.
Sure.
There's plenty of authenticity challenges you can make.
Tell the listeners a little bit about authenticity challenges. So explain that.
So you overcome the hearsay objection, but then we need to know that it's actually a valid document. Do you actually know what this is? Can you state with certainty that this is a picture of what you say it's a picture of? Is this the actual lease? Is this a certified copy of something, or is this something that you transcribed by hand that's supposed to be an exact copy but isn't? So there's a lot of other things that can go into it.
Yeah. Let's talk a little bit about videos, okay? Because this is a hot topic right now. Do you do much scrolling on social media?
I try not to. Probably about as much as anyone else.
You get locked in sometimes. I manage the firm's social media accounts. I do a lot of social media. These videos, these podcast videos get chopped up and posted on social media. And when
they started showing up on my feed more. I love seeing us on my feed.
Yeah. So I've been getting tricked by these videos recently, okay? And what happens is I'll see something crazy, almost unbelievable, and I'll watch it for 30 seconds. I'm not a scroller, but I'll watch it. And then I'll wait a minute. I say, wait a minute, that doesn't seem right. For example, they showed me one video where a guy was getting sentenced, and you know how they put the criminal in those glass cases if they think he's dangerous or whatever. So the criminal's in a courtroom with getting sentenced. He gets 30 years, and the bailiff is next to him. And the guy basically, he's in handcuffs. He scales like Spider-Man, the glass case, and gets into the ceiling, gets through the ceiling tie. And at first, it looked amazing. I was like, wow, that guy's a gymnast. And I was like, wait a minute. And then I examined the video a little bit more, and I was like, this is not real. This is obviously AI generated. But it could have been. It could have been real. The videos are getting really good right. Have you heard of Nano Banana?
I have not.
Okay, so Nano Banana is the video generator, the image generator that Google has, and their image generator. I don't know if Nano Banana generates videos or not, but the image generator is really good. And you can't tell the difference. It's crazy between what's real and fake. So I want to hear from you, like, how does the AI technology make our jobs as officers of the court, as lawyers, how does it change what we're doing, and how does authenticity in play with all these AI videos that could just be fake?
I imagine it makes life more difficult behind the scenes. I certainly haven't run into that. Someone's trying to pass off a fake video or fake evidence. In the real estate context, we deal with a lot of fraud, unfortunately. And we hear radio ads now for real estate fraud because someone actually wised up and realized how easy it is to fake a deed. So we knew we were going to be in trouble when that secret got out. So wonder if changes are coming to that.
Let me create a scenario here, a fact situation. Classic example is always the injured plaintiff who was in a car accident, who's claiming he's got debilitating injuries, is caught playing tennis or something like that. And there's a video of the guy playing tennis. Let's say somebody took a video from, let's say it was a nemesis, a neighbor didn't like Bill, who was in a car accident, and Bill's walking around with a neck brace and cane during the day, but during the weekdays, but on the weekend, Bill's out there at the park playing tennis. So the neighbor who doesn't like him takes a video, and the enterprising attorney for the insurance company subpoenas the neighbor and wants to authenticate this video. Okay. Let's say you're the plaintiff's attorney and your client, I can't remember what name I've given the client, but let's say your client says and swears to you, that wasn't me. That's an AI generated video. What does that look like? Do you think you're going to object to the video and the guy's going to say, okay, I took this video. It's my video. I did not use AI to manipulate it. Is that what that looks like, you think?
Yeah. I think if you've got nemesis neighbor that takes the stand and says, no, I took the video on my phone. We produced it in discovery, and here's the original on my phone with the and the locate, the timestamp. We've produced it. You've had a chance to have your people analyze it, but I stand by it. I took the video. I know it's a legit video, but you're right. That's exactly what you're getting to is, are we at the point where we need the actual author of the work, or the person who took the picture or took the video, to come on the stand and authenticate it? And strictly speaking, that is the person that you need to authenticate it. No one else can, because only that guy took the video. So he's the only one who knows. But I imagine you have video experts that can also figure out if something's been manipulated.
Yeah, that's a good point. I think we are. My point is, I think we are getting to the place where the authenticity of the person who took the video, who can testify that it was not manipulated by AI, is going to start playing out in the courtroom very frequently. And if that person's not around, and this is somehow you have a video that just gets posted on social media, and you're trying to offer that video into evidence on social media, and you don't have the person who actually took the video, if you're the attorney, you better believe you're bringing up that, Your Honor, objection, that we don't know the video is authentic, especially in the light of AI, that could have been manipulated. There's no way that as a court now, we can admit any kind of photographs or videos without someone who has authenticity on it.
And usually the flip side of that is you're offering something that I didn't take the picture, but I can testify to the contents of the picture. That picture was taken on this day. It's a picture of your injuries. Are those an accurate depiction of your injuries on that day? But like you said, even that, it could be doctored.
This is a new world. And I don't know these experts that you're talking about, how good are they at telling whether videos are AI generated or not? I don't know. It could be like handwriting experts where there's a little bit of sort of artistic interpretation and that kind of thing. It's a problem, but yeah. Okay, look, I think we've done good work here. That short show today, that brings our show to a close. I've been your host, Phil Silverman. Chris Hill has been my co-host. Like us, follow us, review us wherever you get your podcasts. And as a reminder, nothing in this show is to be considered legal advice, and this has all been for entertainment purposes only. If you have a legal question, email us at info@silblawfirm.com and tell us you want it publicly answered in your podcast. Everybody have a great rest of your week and weekend.